This conflict of interest. You only here to make money, man. You know what I'm saying? It ain't no crime.
Wait a minute.
Ain't no
I'm
victim or no loss, bro.
I'm not your, listen, I'm not your man.
Look, sir. Hey, sir, respectfully, you're an Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody.
I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem.
All right, folks. Today we're diving into a fiery courtroom exchange that quickly went off the rails. In this case, Judge Perkins faces off with a self-proclaimed sovereign citizen, and let's just say, things didn't exactly go in his favor. The defendant claimed he missed his court date because, get this, he said he was locked out of the Zoom call. Yes, that was his actual explanation in a legal proceeding. Judge Perkins wasn't having any of it. He listened, nodded politely, and then swiftly denied the defendant's motion without hesitation. And that's when things took a sharp turn. The courtroom tension exploded into a full-scale meltdown, as the defendant refused to accept responsibility and spiraled into one of the more dramatic outbursts we've seen in recent hearings. Missing a court appearance is already serious. But combine that with a smug attitude, legal jargon pulled from the internet, and zero accountability. That's a recipe for disaster, and this defendant delivered it all with confidence. Meanwhile, Judge Perkins stayed composed and firm, completely dismantling the excuses and holding the line on courtroom standards. Let me know your thoughts in the comments. Was the judge too strict or exactly right in how he handled it? Either way, this hearing turned into a wild ride, so let's break it down and see exactly how Judge Perkins took control and shut it all down.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case until you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter for.
Is there any way I can get a written? Can I get a written articulation as to why you're denying the motion?
I'm denying the motion because
I would just appreciate a written excuse. Can I get a written articulation?
I might give it to you in writing.
Are we on record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay. You were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm denying.
I'm saying that no, there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
Okay, I'm denying a motion to dismiss. Okay, I'll set a trial date for you so you can be heard on that type of form.
I insist that the court give me a written excuse as to why you're denying my motion, so I could take that to the tenor. Okay.
Well, you can insist all you want to.
Okay. I appreciate that, but I'm telling you, you're telling me today why you're not going to look into it or give me a hearing, as so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that, so I'm just asking that you can give me a written excuse that I could go take and complain against you on, because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there. Overwhelmed.
At this point, it's genuinely hard to tell whether the defendant is truly confused or just pretending not to understand how the legal system works. What do you think? Drop your take in the comments, because the way he handled this motion and his reaction to being denied raises a lot of eyebrows. Let's break it down. He submitted a motion hoping to have Judge Perkins removed from the case. But here's the thing: a judge isn't legally obligated to provide a lengthy written explanation when denying a motion, especially one that lacks any real legal merit. And in this case, the motion didn't just fall short, it was baseless from the start. instead of accepting the outcome and moving forward. The defendant seemed genuinely offended by the judge's refusal. He acted like the court owed him something, like denying his request was a personal attack. His response, demand a new judge, as if he could just shop around for one more favorable. That's not how the justice system works. The frustration from Judge Perkins was written all over his tone, and frankly, you could tell he's seen this behavior before. What's troubling here is the pattern. Individuals like this often reject responsibility and expect the court to accommodate wild legal theories or personal opinions rather than actual law. And it's not just this one case. Sovereign citizen arguments are popping up in courtrooms across the country more frequently and almost always with the same outcome. Denied motions, increased penalties, more confusion. These strategies never hold up, and yet the movement seems to keep growing. It really makes you wonder, why are people still trying this approach when it never works? The consequences always outweigh the original issue. But for now, let's head back into the hearing and see just how far this one spirals.
So at the end of the day, like I said, there's no crime. This is a fraudulent charge. Y'all don't have, there's no suspect. Y'all suspect me for no crime. There's no victim, no losses. Okay? And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're Article 1 judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime.
Ain't
no victim or no loss, bro.
Listen, I'm not your man.
Look, sir. Hey, sir, respectfully, you're Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody. I'm asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, that's all we need. I don't want to hear any more.
All right, cool. It's cool. I appreciate it. This is due process. This is a due process violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They're not prepared to present a case. I'm telling you. They're not prepared to present an injured party. So what are we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You take whatever. Wait a minute. Let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have the opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it that way, okay?
Upcoming jury trial is shaping up to be a real challenge, especially for the sovereign citizen at the center of it all. If the pretrial hearing was any indication, things could get chaotic quickly. Honestly, I'm genuinely curious to see how it unfolds, and if you are too, let me know in the comments. If there's enough interest, I'll make sure to cover it in the days ahead, but let's talk about what just happened. What's your take on this hearing? I'd love to hear your thoughts, because for me, this one left more questions than answers. In some strange way, it almost felt like the sovereign citizen walked away with a small win. He openly challenged the judge, spoke out of turn multiple times, and somehow faced no immediate consequences for any of it. Now, typically, disrespecting a judge in open court can land someone in contempt pretty quickly. But in this case, nothing. No fines, no penalties. No warning beyond a verbal redirect. It makes you wonder, has the shift to virtual hearings changed how courtroom decorum is enforced? In person, that kind of behavior wouldn't fly for a second. But online, it seems like some defendants are getting away with much more than they should. Honestly, I thought Judge Perkins might take firmer action, but for whatever reason, he chose not to escalate. Whether that was a strategic decision or simple courtroom patience, it's tough to say. But it's clear this sovereign citizen isn't backing down. And if this goes to a jury trial, it could be even more unpredictable. That wraps up this hearing for now. If you want to see more coverage like this, let me know. And don't forget to like, subscribe, or drop a comment if this content resonates with you. Thanks so much for watching, and until next time, take care and stay informed.